All right, welcome everyone. My name is Jamil Isidor and I'm an attorney with the Dominican Bar Association. I am president and just want to invite you and thank the Puerto Rican Bar Association and the South Asian Bar Association for co-sponsoring with us on this redistricting event. We have Cesar Ruiz here from Latino Justice, and he's an attorney there. He's going to be talking to us about the redistricting process very quickly, about the state Senate side and also the New York City, what's going on with New York City and how we can all get involved. So thank you so much for being here, Cesar Ruiz, and I will hand it off to you to tell us about redistricting.
Thanks, Jamal, and thank you to Dominican Bar Association, Puerto Rican Bar Association, and the South Asian Bar Association. Conversations about redistricting can be a lot, so I'm promised to make this as painless as possible, while also giving you all the information about a process that really determines so much of the way that we do our work and live our lives. And so I guess it just makes sense to start with like a run of show. I'm going to start off with the run through of a statewide process. We kind of have heard a lot about that, or, you know, the dysfunction kind of boiled into that. So I wanted to touch a little bit on that. I wanted to discuss, you know, where we are now, and then shift to like the city redistricting process to assess like what opportunities exist there. And so I'm going to share my screen. I have two separate PowerPoints. So I'm going to open up the first one. Just give me 1 second. Great. So talking about, I recently did a presentation, and this is kind of a reflection of that. We do a debrief on like the statewide process, and really we wanted to look at what the issues were, what kind of came up, and how things happen. And so I created a helpful visual that I hope like can guide us at least through some of the things that went on, because a lot of things really went on. And so the first piece that really happened was this new commission that was appointed. So in 2014, the state passed an amendment that created the Independent Redistricting Commission. And so this cycle, what we saw was an engagement of that commission, the formation of it, and then for the first time ever, an opportunity for public engagement. And so working through the timeline, we can see it began with the appointment of the commissioners. So there were 10 commissioners, 4 appointed by the Republican minority party, and then 4 appointed by the Democratic Party, and then 1 by each of the 4 appointed individuals. And so that kind of set the stage for a lot of what would follow. The first submission was a dueling set of maps. They couldn't agree to a set of maps, and that was part of the tension. So they submitted it twice. They submitted to the legislature rejected those maps. They submitted again, and then the legislature ended up adopting their own maps. And so that's where like the state driven process ended. But in between that, there was a lot of community input and engagement. At Latino Justice, we were a part of the Unity Coalition mapping effort, which really looked at how we equitably build maps for Latino community members, for our Asian American community members, and for our Black and African American community members. And that was a partnership that we held, and that was strong, and that was good in a lot of ways, in that it brought light to a lot of the inequities built into this process. So that was phase 1, which we all knew was going to have its problems and its issues, but we all did what we had to do, and the community showed up and showed out, which is really important and makes a huge difference. The second is kind of like the legal phase, and this is kind of where things got interesting. We knew that the maps would be challenged. A lot of folks on the ground, especially a lot of experts, didn't think that the challenge was going anywhere. We had some new amendment language, but none of it explicitly created a cause of action, and so folks were skeptical that the courts would strike it down. So we see groups challenge congressional and state Senate maps. A state trial court invalidates those maps. That decision was interesting for a lot of reasons, but mostly because it didn't really cite to the record. It didn't really deal with, the substantive issues. It just ruled the map unconstitutional on its face. As we know, it goes to the appellate process. So it went to the appellate division, and the appellate affirmed in part and they reversed in part. And what they found was that there was a partisan interest in those maps, and that made certain aspects of the map unconstitutional, particularly the congressional maps, which they found to be more egregious than the state Senate maps. So it works its way up. Folks are really confident that the Court of Appeals is going to overturn that decision, and that the maps created by the legislature, which were devoid of public input, really were created behind closed doors in a lot of ways, and only engaged with certain or members of like the Democratic Party, which is incredibly dangerous because it kind of shuts out the public comment piece, which was critical to creating a lot of what was reflected in at least some versions of the A and B maps that the commission put, but also in contravention of those. And so the Court of Appeals, it reaches the Court of Appeals, and the Court of Appeals rules that both maps were procedurally and substantively unconstitutional. And the significance of that is that it created a cause of action that I don't think a lot of folks saw. The language of the amendment did not create any real cause of action, in that it didn't say that you could explicitly sue the state legislature or government, and the bar was really low. All they had to was consider the maps by the RSC Commission, or and that was it. It was just consider, so it was a very low bar. And this was a decision that I think surprised a lot of folks, but that kicked off the next phase. And the grounds for that was that the legislature didn't find it procedurally correct. They kind of skipped some parts, and there's like a lot in that decision, but then they substantively ruled, which I think a lot of folks were more surprised about, because again, like the language didn't create a clear standard by which to judge it, but they ruled that it was substantially unconstitutional because it was a partisan gerrymander. So that meant that the court would appoint a special master. And so this is when the project shifted, the process shifted to the special master, which was something that we've experienced on the congressional level before, but never in this manner. And so that kicked off the last phase. So the first thing that had to happen was that the congressional and state Senate map or state Senate primaries had to be shifted. Notably, they didn't rule on the assembly maps because the challengers had amended their complaint only to include state Senate, but they hadn't included state assembly maps. And so that meant that we got congressional and state Senate primaries. They had to be moved from June, which we typically hold our primaries, to August. And now that's why we have two sets of dates for two different and distinct sets of primaries. So the next piece is that the special master begins to develop these maps. And a lot of disappointment in that was that there was only one opportunity to testify in court. It was all the way in Steuben County, which is about like 3.5 hours northwest. So it was really inaccessible, and a lot of folks weren't able to kind of have their voice heard. There were a lot of calls to hold more hearings, understanding what's at stake. All those kind of fell upon deaf ears. I was able to go there and testify. It was a really unique experience, but we were able to and we had a good amount of community showing, particularly within the Latino community, which was great to see. But it was a very quick process. It was about like a process of like over 2 weeks. And then the courts adopted the special master maps. And there was one draft, and then there was opportunity to comment, and then there was the final draft, and then it was adopted. So that was the end for the congressional and the state Senate, but we still had the assembly. So groups similarly challenged the assembly maps, which weren't invalidated by the Court of Appeals. And this process is still ongoing, but we have had at least some clarity within the last week. The appellate division and the Court of Appeals denied that there were any constitutional issues, and the appellate division found that the assembly maps suffer the same infirmity. So it's the same partisan gerrymandering, and that they have to be redrawn. So the distinct the distinction there is that those maps, it's too late. So there was a claim of laches, essentially saying that they kind of sat on their rights and that it was too late to bring in, that it would cause a lot more upheaval. So we are going to be using the assembly maps for the upcoming election, which is ongoing. Early voting already started, and election day is right around the corner. So the courts said it's not feasible. But those new maps, there will be new maps for 2024 instead of 2022. And these challenges are still ongoing. So likely that we will have, similar to the other maps, a special master appointed, and that process is still ongoing. And so that's kind of like the very quick and dirty of how it went. As you can see, it's not very difficult. There's like 3 phases, but that's at least some insight into kind of what the statewide process, and a lot of it is still up in the air while the courts have ruled. We still have yet to see where this process kind of shifts. And so I will stop sharing, pause for a minute, give folks a minute to digest that, and then kind of just discuss. And if folks have questions, you can feel free to put them in the chat. If not, it's totally fine. I think I'm just going to move forward and then address questions at the end and create space for that. Great. So in terms of where we are now, I discussed a little bit about the statewide process. So the statewide process is where we just left off. So there's a new assembly maps that we expect for 2024. But we now sit in a very unique position, and now we're preparing for New York City-wide redistricting. And this is a lot more local. It's how city council districts throughout the 5 boroughs are constructed. And it's a really, really important process, because we're stuck with these lines for the next 10 years, but it's also going to determine our local politics and how we're really going to be engaging folks through that process and what kind of resources. And so shifting gears a little bit, I wanted to go over, what the New York City redistricting process is like, what kind of some of the legal standards that are, and just what is the process like. So where we are now is really gearing up. We timed this, we had planned this a while back, but they had announced after we had already planned it that they're having preliminary hearings next week. So this couldn't be actually more timely, which is exciting, but also gives us an opportunity to not only shift from understanding what this is, but being more action oriented, which is a lot of the work that we're doing at Latino Justice. And so I'm going to share my screen once more and pull up. Here we go. Perfect. So shifting gears, New York City redistricting. As I mentioned before, we're just beginning this process. They've already had the commissioners appointed. So we have 15 commissioners. I'm going to go through kind of the breakdown of that, but we already have a commission in place. And the city charter kind of mandates, and we're right at the point where we're about to start public hearings, but we haven't seen any maps just yet. And so about us, Latino Justice is actually celebrating our 50th year this year. We had an incredible event yesterday where we were able to kind of connect and reflect on the work that we've been doing. So this is a little bit about our mission. We are a civil rights organization. We've been doing this work for over 50 years, particularly within the redistricting context. We've been involved with for the last several decades. And so we've been involved in advocating for equitable maps for Latinos for about 3 to 4 decades, which is incredibly significant and something that we take to be very important. And so shifting gears into more of the substantive, I wanted to just go over what is redistricting. I don't assume that everyone knows what redistricting is. So I just wanted to always begin with like a basic understanding. And so redistricting is the redrawing of electoral districts that reflects changes in population as measured by the census. It happens at the congressional, state, and local levels, and we touched a little bit about that on the statewide process. Particularly, we'll be looking at the statewide process. And so we want to understand kind of what that's about. And essentially, at the core of it is ensuring that everyone's vote counts equally And that's what a lot of the case law and the reason that we kind of recalibrate, because we understand that there's shifts in a population and that we have to account for that, and that everybody's vote should be weighed equally, and that it's really significant that we kind of engage in this process to make sure that we capture all that. Why does redistricting matter? Again, I think it's important to kind of frame the conversation about why this is important. And really one of the big points is that it shapes your ability to elect representatives who represent you and your community and your interest. And so it's a really key aspect of our democracy, and it's really important. The next piece is resources. All of this is directly tied to what resources you will get, what funding you get, what transportation you have, roads, schools, hospitals, libraries, all these kinds of things are implicated by this. And so it's important for many of those reasons. And so similarly, it can impact your quality of life. What representation you have, what districts you're put in, and where your representation is derived from affects all of these things. And that's why redistricting is so critical, because it implicates all of these various things. Another important note is that we're stuck with these for 10 years. So this is not a process that happens every 2 years or every 3 years or every other year. It happens only once every 10 years. So it means that with these districts, we'll have them for the next 10 years, and they will govern our community until the next census. And so it's critically important that we engage in this process now so that we can see the benefits of our communities being adequately represented and their interests being met. And lastly, it just looking at the gambit of things that can affect it, if your community is represented by the same person, whether a representative feels responsible for your concerns, and then lastly, who wins an election, controls the legislature, and even what laws are enacted. So all of this is really big picture, affecting a lot of things that impact, how we as attorneys do our work, how we show up for our clients and community members. So this is a process that really matters, and that does affect that all. Sorry, I have I don't really like the, okay, perfect. Key terms. So there are a lot of things. I remember when I first started, like 10 months ago, I was really confused because there's all these terms that people kind of just talk at you. So I really like to break stuff down. There's a lot of talk about voting age population within the context of redistricting. And so that sounds like a lot, but all it is the number of individuals of voting age who are above 18 years old. And so that's a metric that we use to measure representation when we're looking at how a district works and how it functions and how we can ensure that community members are represented. And so.
Hey, Cesar, just so you know, the slide is still on the first one. So okay. I think you're talking about slide 5.
Okay. So
from my, it could be me, but from my end, I'm on top. Yeah.
It's changing. Okay. How about now? Has it shifted?
No, I'm still seeing.
So I'm going to stop my share and then I'm going to start it again. Thank you for letting me know.
Sure.
Because that would have been brutal. Just bear with me 1 second. Okay, turn this off. Okay, 1 second. Thank you for bearing with me. Just want to make sure we're all good. Okay. Perfect. And now does this slide come up?
Yes.
Okay, perfect. Thank you so much. So key terms, we talked a little bit about voting age population. So it's the number of individuals of voting age, and that's how we derive representation. So second metric and something that's commonly used is communities of interest. So this is a community that has similar economic, social, and cultural interest. And this is really key to defining your community, advocating for your community, advocating for maps that are mindful of how communities are made up, And we'll go a little bit deeper into this, but I just at least wanted to give you some context into what some of the key terms are, especially this term, because it's a very critical term in how we advocate for this. Majority. So it's used a lot, particularly within this conversation, but it's where a particular racial or ethnic group represents more than 50% of the population within a particular district. And this bleeds into like some of the legal analysis, but it's important to have this understanding of the significance of a majority, and just have like a basic understanding of it to guide you through some of the more tedious and in-depth concepts that we'll talk about later. Plurality. So this is where a racial or ethnic group doesn't represent the majority, but it does consist of a significant portion of the population. So 35% of a district could be considered a plurality. And so it's another measure or metric when you're looking at how you want the makeup of a district to look and how you want to argue for representation of your community or even within a particular district. Deviation. So it's the number of individuals from ideal population. And so that has significance again with some of the conversations we'll have about some of the legal standards. Deviations are significant in that certain levels of government are governed by looser or more strict standards of deviation. And so this is like if you put all of the individuals that live like throughout New York, and then you divided it by the number of like, let's say state Senate seats that we have, that would give you the ideal population. And then any number away from that number would be a deviation. And so again, I'll dive a little bit deeper, but I just wanted to at least introduce it initially. Now we're gonna shift into some of the governing law. And I just wanted to check in, Jim, out did that change with the slide?
Yes.
Okay, perfect. So the first basis is the US Constitution, particularly apportionment, which is a process that's set out on the federal level, and then the 14th Amendment. And so we're gonna dive a little bit deeper, but I at least wanted to just start with like a basic overview. The Voting Rights Act, we've heard probably a lot about this. I've heard nonstop about this. Attacks on democracy are more than alive and well. They're thriving in a lot of state and local legislatures, and the attacks on the Voting Rights Act are very much kind of chipping away at that. We saw Section 5, which pre-cleared, which prevented a lot of issues that we see coming up, but it's a strong piece of legislation that governs this entire process. The New York State Constitution, and this was more for the statewide process. Not much on the implication, has some implication, but not much implication on the local process. But we also just passed the New York Voting Rights Act, which is going to shift some of the dynamics where we don't have like some of the federal protections, some of the New York Voting Rights Act protections will come into play, and that will be something that we add to this presentation, but its effective date is not until July of 2023, so we have some time before then. The last piece is the city, county, and municipal charters, and for New York City, it is the New York City Charter. And so again, this is just a brief overview of like what each one is. I'm going to go into each one in turn and just highlight significant areas of the law that really touch on each aspect. So first, just start with federal law. So I talked a little bit about the US Constitution, apportionment, and the 14th Amendment. And really that concept is one person, one vote. So this goes back to deviations and how we want to make sure that everyone's vote is counted equally. Historically, a lot of jurisdictions on the state side manipulated the redistricting process so that they could have a bunch of individuals grouped in one district and then have like unequal representation. So what the concept is under the 14th Amendment is that every vote has to be equal in weight, particularly on the congressional level. You can only have a deviation of like less than one. So that means that it's very tight. It has to be very close to the ideal population. On the state and local levels, states are free to govern, which means that they have more flexibility in terms of the ways that the courts have regulated this on the federal level. They've said that within 10%, which means that you can shift population to be more or less equal within the districts and you have more flexibility, but it does have an effect on the weight of the vote, but they've allowed more discretion on the state legislative maps, so the state Senate or the state assembly maps. But Baker v. Carr is really, and Reynolds v. Sims are the cases that kind of discuss that. And really, it's just a very simple concept of your vote equals the vote of somebody who lives in either in another district or another state. It just has to make sure that it's proportional and equal. Not proportional, but equal. And that's a very distinct and key process or part of the law. And this just kind of showcases a little bit of what that means is just mathematical equality. And then the state and local, as I discussed, it's a 10% kind of deviation leeway. It's important to note at this point, when we're talking about deviations, the federal law is the floor, not the ceiling. So states can qualify and New York law has qualified. And so there's a smaller deviation. So it's a 5% as opposed to a 10%, which is a pretty significant limitation on the way that you can draw, but it doesn't mean that it just wants to keep it in a way that the votes are nearly equally in weight as possible. And so the state has prescribed that. Shifting gears a little bit from some of the equal protection and one person, one vote concepts, it is Section 2 of the Voting Rights Act. And this has been a significant tool in the fight for rights of marginalized community members. And so I wanted to just spend some time talking a little bit about it. This protects against vote dilution, and vote dilution has many forms and flavors and profiles, but essentially it is trying to harm a community's ability to elect a candidate of their choice. And the legal standard is Thornburg v. Gingles, and that's like the seminal case. That's the case that really defines what is this cause of action and what's the harm and all these kinds of things. And so it created a framework for numerosity, racially polarized voting, and it affirmed Congress's totality of the circumstances test. And that is a lot of words, but it's essentially created a test for us to be able to argue, hey, this map harms community members, particularly African-American, Latino, Black, Asian community members in a way that doesn't allow them to elect candidates that represent them or their community's interest. And so I wanted to just go briefly over the standard and kind of walk through each piece. So the first question and the first thing that you look at is whether the population is sufficiently numerous to form the majority. And I had mentioned this before, a majority is anything more than 50% of a district. And so when you're arguing that that a plan is diluting the vote of, let's say, Latino community members or African-American or Black and Asian community members, you have to have enough population to argue that they're harming your community in a very distinct way. And so that's like the first problem. The second piece is political cohesiveness. So this really looks at, do they vote together? Do individuals in these districts that you're alleging are diluting their vote, do they vote in the same way? Because, and the rationale has been explained that if they don't vote together, then what is the harm? And so that's a lot of what the thinking is behind this. So you have to have political cohesiveness. And this, you look at political data to see how do members of community vote? Do they tend to vote for the same candidate of choice? And you want to just make sure that as you're kind of building your cause of action, you look at the cohesiveness of members within this. Third is you're asking, does the majority block, and it's typically the white block voters, do they vote consistently to defeat the minority preferred candidate? And so you have to have all three of these to survive a summary judgment. And then it also shifts to the Gingles factor or the Senate factors. And so those three give you a very strong chance that you will prevail. And so if you have sufficiently numerous to form a majority in the district, you have a 50+1 and they vote cohesively, and this majority block votes to block their candidate of choice, then you have a cause of action under Section 2 of the Voting Rights Act. And that's pretty significant because that's the basis of our advocacy within this space. And it governs how we're able to kind of protect the interest of folks. And so there's also the Gingles factors, and this is kind of just assessing really the historical impact and just reinforcing the totality of the circumstances. When the Senate passed this law, they created a bunch of factors that we had to consider. And so this really just looks at the context of it. Pretty much when you have 1, 2, and 3, it's a strong chance because it's a very high burden already. So the Gingles factors just kind of tease out some of the historical impact and assess really the totality of it. And so that's pretty much the Voting Rights Act, Section 2, and that's a brief overview. And so I wanted to just give some insight, understanding that we have legal minds and that we're all kind of working within the space, but this is a very bird's eye view of a really significant protection that is consistently under attack and currently up in the air as to what this will look like after this Supreme Court rules on several challenges that have been coming up. And so I wanted to shift a little bit to state law and its implication on the citywide process. So I had mentioned the 5% deviation that's built in by state law, and that imposes it on local legislatures, so they can't exceed 5% of the average population or the ideal population. I had mentioned before that the New York Voting Rights Act was recently passed, so where we lost Section 5 preclearance, and I'll just go briefly. Section 5 preclearance and the significance of it was that it held a lot of voter suppression laws in areas where there was history of racism and discrimination against marginalized community members. And so in 2013, we lost the formula for that provision of the law. And so that's why we're seeing a lot of new laws and a lot of new voter suppression laws being able to be passed through state legislatures, because they don't have to go through the process of preclearance. And preclearance was they had to submit the law to the Department of Justice, and the Department of Justice had to give a detailed report assessing what impact it has on African American, Black, Latino, and Asian American community members, and whether it had the effect of harming their prospects to elect candidates of their choice or harming access to the ballot. And so on the statewide level, we lost that on the federal level in 2013, particularly the formula, which essentially means that it's defunct and we can't use it. And so there's been a lot of efforts to create preclearance requirements on the state level. And thankfully, as of Monday, celebrating Juneteenth, we passed the New York Voting Rights Act, which created local preclearance requirements. And so the Attorney General's office, once the law becomes effective, will have the ability to look at past redistricting plans, particularly New York City and other local redistricting plans, and also look at laws that are passed by local legislatures that can impact access in this way. And so those are two things that are pretty significant. And so shifting gears a little bit, I wanted to talk about the city process. And the city is unique in that the city charter is very specific on how this process will go. And so I wanted to talk a little bit and walk through kind of what the rank criteria, and then also on the back end, just talk about some of the distinctions. And so they have a number of criteria, and it's set out in Section 52 of the New York City Charter, and they list it in order of priority. And this is pretty significant because it gives you a framework. On the state and the federal level, there's not this same rigidness. It is kind of a balancing of interest, but where the state legislature has mandated that it be ranked criteria, they have it on the state level, but where the city has, that takes a priority over some of the lesser ones, as opposed to trying to balance those interests, which doesn't create the same level of accountability. And so I wanted to just walk through, a lot of these are reinforcing, I think, what's built in federal law. So population equality, we talked about that. That's just a reinforcement of one person, one vote. Fair and effective representation of racial and language minority groups. And this is pretty significant that it's the second, but this is also reinforcing Section 2 of the Voting Rights Act, but more, it creates a cause of action where it's saying that it being the second criteria, you can't draw districts in a way that harm the representation of racial and language minority groups protected under the Voting Rights Act. Third is keeping neighborhoods and communities intact. And so communities of interest, as I had mentioned before, people that share the same or similar common social, ethnic, and cultural interests, we want to keep them together. We want to make sure that we're keeping communities intact and that we're empowering them to elect leaders that represent their interests. And so that is the third criteria, compactness. And this is just the district can't be like a coily snake. It can't like reach from like one very far end of the city to the other. It has to be tight and compact. Fifth is it can't cross boroughs or county boundaries, and this is the fifth criteria. The way that the districts end up being drawn, there's usually a crossing, and so the informal rule is that you can only cross a borough once. And again, it's the fifth criteria, so it cedes to all of the ones above it. Okay, and then we have just a few more. Again, it's lesser within it, but it's still within the formula for how the commission will draw the maps. And so you can't draw it to separate geographic conversations of voter by political party. So this is, making sure that they're not drawing it in a way to kind of affect political party interest. And it's similar to the partisan language that we have in our state constitution. So the seventh criteria is that, it minimizes the sum of the length of boundaries within a district. This is just guidance, not guidance, it's law, but another factor. Again, it cedes to a lot of the additional ones listed above. Contiguity. So all this means is that you have to be able to walk from one end of the district to the end of the other. And that's all that contiguity is. The second piece is if any district includes territory, then another district may also include territory from the same. And this is similar to what I had mentioned before, where you can only cross a borough once. So you can't cross two of the same boroughs twice, which limits the ways that you can draw. And just sharing the source, if folks want to take a look at this, I doubt it, but there to kind of see where the law is and where it comes from. Okay. Gerrymandering. And I know that was a lot, like legal heavily. A lot of it will come alive, I think, in like this portion of it. So gerrymandering, I think folks in some way, shape, or form have been exposed to gerrymandering, and I just wanted to define it. So gerrymandering is the practice of drawing the boundaries in a way that gives either a political party an unfair advantage or just dilutes the voting power of members of an ethnic or linguistic minority. And so there are really two distinct types of gerrymandering. There's partisan gerrymandering, as you can see through the statewide process. That was the court's reasoning for ruling the way that it did. On the federal level, there's not standards to judge that, but the state has made it clear that they have an interest in regulating it, and some states have. And then there's racial minority or racial gerrymandering. And this is unconstitutional and illegal, and it's not permitted. And so gerrymandering, racial gerrymandering, is unconstitutional under federal law, and it regulates the entire process. Visually, I think it's always helpful to see kind of what gerrymandering is. I think it's a term that's thrown around, but it's not really kind of engaged with. So this is a helpful visual. As you can see on the first graphic, it's 60% blue, 40% red. Perfect representation is, one each column. So three blue districts, 2 red districts. The third graphic is a way that you can draw the district where there's 5 blue and 5 red. And you can see the outcome of the way that you draw the districts and how you can influence this process. And so under the first one, blue wins 3 out of the 2. And so they have 3 blue districts and 2 red districts. On the third graphic, you can see that you can draw in a way that blue wins every time. So it's compact, but it's not fair. So it doesn't really allow anybody that would be living in the red district or anybody that's representative of red to elect a candidate of their choice. And then there's the last one, which is another form of gerrymandering. And you can see kind of how it's drawn to be unfair to the red or to the blue districts. And so these are different forms of it. When you draw maps, this is something that is kind of implicated in this. The way that you draw maps will affect either partisan interest, which again is not protected in the law, or racial interest. And that's really where our advocacy at Latino Justice, alongside several of our partners in the racial justice space, really focus on is what impact does this have on Latinos? What impact does this have on African American Black community members? And what impact does this have on Asian American community members? And how can we show up and protect those interests? And so I want to talk a little bit about the role of city council. it's purely advisory in nature. And this is something that I'll dive in a little bit deeper. But I'll just say right now that it's a different role than what we have on the state level. Second, they can list objections, but the commission has the power to they have to reconcile, so they have to engage with those, and then they have to produce an additional map. Ultimately, the commission can adopt maps despite the council objections with the support of 9 commissioners. And this is very different from the statewide process where the commission didn't have that. And so shifting and talking a little bit about Latino representation, and actually going back a minute, I wanted to just talk a little bit about process, because I realized kind of diving in, I might have stepped forward of this. The process in the city is we have 15 commissioners. They're appointed by various apparatus, some by city council, some by the mayor, and some by the minority party in the city council. And so that gives us 15 commissioners. These 15 commissioners are in charge of drawing the city council maps, which will go into effect in the June primary of 2023. And so all of the governing law you saw before determines how they will draw these maps. And the role of city council is important because we look at what they can do to kind of play their role in the process, but also how they can affect the process. And significantly, the commissioners have the ability to reconcile the objections that city council may have, but they can also override it. And this is very distinct and important because it means that they're not subject to the legislative body that will be represented or has like a personal stake in that process. And so thinking about representation on Latino justice, we're focused on advocating for equitable Latino representation, and looking at the numbers, we make up a significant portion of the population of New York. So we're 28.3%, which is about a little over a quarter of the population. And we want to make sure that our representation matches that in the representation that we have on city council. And so as a community, we really want to advocate for representation that mirrors our community's total population across the city. And as it stands now, we're proud to say that we have 15 city council representatives that identify as Latino or have Latino heritage, which is really significant because that means that we're doing the work that we have to do, and that these maps have reflected the community's interest in being able to elect candidates that look like them, that represent their interest, and that the population is benefiting from that representation, which is really significant. I just wanted to go over briefly a few of the differences, and I had mentioned them before, but I just wanted to kind of zero in on them. We have rank criteria. That's really important. That guides drawing of these districts in a very different way than what the statewide process is like, which is like you're weighing all of these things, but ultimately the map drawers have discretion and can justify it any which way. With rank criteria, it's top to bottom. So that means we are working from the first criteria, which is equal population, the second criteria, which is protecting racial and language minorities, all the way on through. And it is a formula for how they have to be guided by, and that's really significant because it creates some wiggle room, but not much, particularly with the ones that are higher priority on the list. Unlike the state process, and I had mentioned this in the previous slide, the city council doesn't have veto power or override power of the maps. And this is kind of some of the dysfunction we saw on the statewide process, where the legislature rejected the maps that the commission made and then drew their own. So this means that community voice and input will be key and central to this, and that the commissioners will be able to adopt their maps despite what city council may think. The last piece is that there's no bipartisan parity. And this is a significant piece because there's no deadlock. Whereas on the statewide level, we saw 4 democratically appointed, 4 Republican appointed commissioners, and then 1 appointed by each of those sets. The citywide process is a lot different because it has, I believe, 4 appointed by the majority party in city council, 3 appointed by the minority party, and then 8 appointed by the mayor. And so it creates the ability for them to overcome the 9-vote threshold, which means that we'll have one map by the end of this process. Timeline. So I discussed that the commission was already appointed, and now we begin phase 2 of this process. And this is kind of just like a brief overview of the timeline. So they have released preliminary hearing dates. Traditionally, we have seen a first map in early June, but the commission has opted to have preliminary hearings so they can hear what the community has to say and engage with that process. So as I mentioned previously, that first round of hearings is next week. So we have June 27th in Queens, June 29th in Brooklyn, smack dab in the middle of primaries, which a lot of us were not really happy about. But we're gonna do what we can to get folks ready and able to like testify and engage in this process. The week after, we have the Bronx hearing, and then the day after, we have the Staten Island. And so that will be the culmination of the preliminary hearings, and then it'll shift to the next step in the process. So we expect a first draft based on communications that we've had July 18th. It could be subject to change. There has been a lot of shifts in this process so far, but this is the date that we expect the first draft. And the maps will be made public after that. And that'll kick off a second round of hearings. And what we've heard through our networks is that the public hearings in response to the first draft maps will be held on August 15th, 16th, 17th, 18th, and the 22nd. And typically you can see that there's one held in each borough so that everyone in the borough has a chance to participate in that process and speak on the representation of their community, which is really important and really significant. And this was also built into the city charter. So this is not an option that they have. This is not something that they do for good grace. This is something that we have built into our laws. And so they haven't yet published which is for which borough, but that information will likely be forthcoming. The next step in the process is submission to City Council. So they're going to vote on the maps on September 15th, and then they send the first draft of maps to City Council. And so this is where City Council can look at them, they can list their objections, they can, say what they want to say about the maps, and then it will kick off a third round of hearings. So first step in between that, the commission will reconcile the differences, and then we'll have a third round of hearings. And then the final submission we expect to be on December 7th, and the final map will likely have the deadline would be for February 7th on 2023. So that's a bird's eye view of like some of the key dates. As you can see, it kind of goes map release, hearings, hearings, and then submission to City Council, and then another round of hearings. So it's always kind of going back and forth, and it follows this timeline that was also spelled out in the city charter. Gearing up towards the end of it, I know this is a lot of information, but wanted to discuss a little bit about the work that we do and the significance of it, because it is important that we put this in context to why we care. So we want to ensure that the new districts are fair, equitable, and they capture the strength and growth of Latino communities. Latinos throughout the history of New York and throughout this country have not been treated equitably, and I don't think that's a secret on this call or in any of the spaces we hold. I mean, we see within the context of the legal profession, the fact that we make up 20%, or particularly in New York State, 19% of the population, but we don't match that. And then across the nation, only about 4% of Latino lawyers, and that's a pretty significant number, but it also shows that it is directly tied to kind of representation and how laws and structures are built. So we fight to make sure that these are fair and equitable, understanding that implication. Two, we want to engage Latinos in this process. It's really critical. We know that this information has not been readily accessible to our community, and so we're doing all the work that we can to make sure that our community members know what's at stake and know what they can do about it. And so it's a really critical role that we play alongside our partners to kind of get the word out and get folks involved. Three, we want to promote Latino advocacy. We want our community to take ownership of this. and to live up to the moment and seize that moment and really understand that they have power, particularly within these spaces, to testify and to speak on their communities and to speak on their representation, and they have every right to, and that they should be emboldened to. And so we work to provide those resources and promote Latino advocacy because we know that visibility is important and so is representation. So that's a little bit of my contact information. I can also share it in the chat. I am more than happy to connect with folks on the call or even via email. This is really important to me. I'm very happy to talk about this work, and I thank you all for attending or even watching. And I thank Jamel for setting this up, the Dominican Bar Association, incredible partner, as well as Puerto Rican Bar Association and the South Asian Bar. But thank you so much.
Thank you so much, Cesar. Great presentation and very informative. So much to take in. And I would say for everybody to look out for those dates, definitely have your voice heard. And if you have any questions, you can reach out to Cesar Ruiz and Latino Justice. They can also provide you some additional resources to help with that, with any statements you want to make at these hearings. Right?
Yeah, thank you. Thank you, everyone. And yeah, please reach out. We're going to be hot and heavy for the next few weeks, but we're definitely more than willing to help folks out.
Great. Thank you so much.
Thank you. Take care.